Police just gained new powers to enter your home without a warrant, and this changes everything for 330 million Americans. What happened today in the Supreme Court will determine whether armed officers can legally break down your door tomorrow morning. And here's the shocking part. All 9 justices agreed on this decision, including the ones who usually never agree on anything. The Supreme Court just handed down a unanimous ruling that fundamentally alters when law enforcement can enter your private residence without judicial oversight. This isn't some minor legal adjustment buried in bureaucratic paperwork. This directly impacts your Fourth Amendment protections, especially if you're a gun owner or have ever dealt with mental health challenges. The case that triggered this massive shift started with a simple phone call that ended with a man being shot in his own home. Let me break down exactly what this means for your constitutional rights, because the details of this case reveal a deeply troubling pattern that could now legally repeat itself at any doorstep in America. The unanimous nature of this decision makes it even more significant. When justices who typically disagree on everything suddenly align, you know something fundamental has shifted in American law. The case centers around Trevor Casier, a Montana resident whose ex-girlfriend made a fateful phone call to police. She claimed she had a bad feeling after speaking with him on the phone. She mentioned something vague about hearing him reference a firearm and expressed concern he might harm himself or potentially shoot responding officers. But here's where it gets interesting. When 4 police officers arrived at Casier's home with the ex-girlfriend in tow, she suddenly couldn't remember exactly what he had said. She admitted she just had this undefined bad feeling about their conversation. What happened next would become the foundation for today's landmark ruling. The officers spent 40 minutes outside Casier's residence. They knocked repeatedly, shined flashlights through windows, and called out his name over and over. Through the windows, they spotted what appeared to be an empty handgun holster and a notepad. Despite all their attempts at contact, Casier never responded. He exercised what many believed was his constitutional right to simply not answer the door. But the officers didn't leave. Instead, they made a decision that would echo through the American legal system. They entered his home without a warrant, without permission, and without any concrete evidence of an emergency. What they found inside led to criminal charges against Casier, but more importantly, it sparked a constitutional battle that reached the highest court in the land. The Fourth Amendment has long been considered one of our most sacred protections. It declares that people have the right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. For over 2 centuries, American jurisprudence has held that a person's home is their castle, requiring law enforcement to obtain a warrant based on probable cause before crossing that threshold. However, the courts have carved out limited exceptions over the years. One such exception is the emergency aid doctrine, sometimes called the community caretaking function. This allows police to enter without a warrant if they reasonably believe someone inside faces imminent danger or serious injury requiring immediate assistance. The question before the Supreme Court was whether the officers' actions in Casier's case fell within this narrow exception. After Casier was shot and arrested in his own home, his legal team mounted a vigorous Fourth Amendment challenge. They argued that the warrantless entry violated his constitutional rights and demanded that all evidence discovered inside, including a handgun found in a laundry basket in his bedroom, be suppressed. The case worked its way through the court system, eventually reaching the Montana Supreme Court. In a split 4-3 decision, the Montana Supreme Court sided with the state, upholding Casier's conviction and allowing the evidence to stand. But they made a critical error that would ultimately lead to today's unanimous reversal by the U.S. Supreme Court. Instead of applying the proper legal standard established by federal precedent, Montana's highest court appeared to use a much lower threshold called reasonable suspicion. This distinction might seem like legal hair-splitting, but it's actually fundamental to understanding your rights. Reasonable suspicion is the standard police use for brief investigative stops on the street. It requires only specific facts that would lead a reasonable person to suspect criminal activity or danger might be present. It's far less demanding than probable cause, which requires a higher degree of certainty before taking more intrusive actions. The U.S. Supreme Court had already established the correct standard in a 2006 case called Brigham City v. Stewart. In that unanimous decision, the court held that officers may enter a home without a warrant when they have an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. This standard sits somewhere between reasonable suspicion and probable cause, creating what legal scholars call a middle ground. During oral arguments earlier this year, the justices pressed both sides on what objectively reasonable actually means in practice. Casie's attorneys argued that the officers lacked sufficient justification because the ex-girlfriend's report was vague, unreliable, and based on nothing more than a feeling. They emphasized that Casie's had every right to ignore police knocking and that his silence couldn't transform a non-emergency into an emergency. The state countered with multiple factors they believed justified the entry: a report of potential self-harm and threats against police, knowledge of Casie's mental health history, the visible empty holster suggesting a gun was somewhere in the house, and complete silence despite extensive attempts at contact. They argued that requiring absolute proof of injury before acting would defeat the entire purpose of the emergency aid exception. In today's unanimous opinion, authored by Justice Ketanji Brown Jackson and joined by all 8 of her colleagues, the Supreme Court definitively sided with law enforcement. Rather than sending the case back to Montana with instructions to apply the correct standard, they applied it themselves and concluded that the officers acted properly. The court reaffirmed that police don't need probable cause to enter a home without a warrant when responding to a genuine emergency involving potential harm to an occupant. They emphasized that the test is objective. It doesn't matter what officers subjectively thought or intended. What matters is whether their belief that entry was necessary would be reasonable to an objective observer evaluating the situation.
Gun rights are at the forefront of discussion today.
What's it take for an officer to determine there's an emergency and then enter into your home?
Loophole that police are using to get inside your home without a warrant. A unanimous Supreme Court ruling gives you the power to stop them.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
Police showing up at the wrong address or receiving bad intelligence, storming in, damaging a house, traumatizing a family.
Justice Jackson wrote that the Fourth Amendment doesn't require police to stand by and do nothing in the face of imminent risk to human life. The court walked through the specific facts that made this entry objectively reasonable. A credible report from someone who knew Casease personally, officers' knowledge of his mental health history, the visible empty holster corroborating mentions of a firearm, and 40 minutes of complete silence despite repeated attempts at contact. This ruling creates significant implications for homeowners across America. Law enforcement now has clarified authority to enter homes without warrants when they believe someone inside faces serious injury or imminent harm. While this doesn't grant unlimited power, officers still can't enter just because they're curious or want to investigate crimes. The standard is notably less restrictive than requiring probable cause or proof of an actual emergency. For gun owners, this decision raises particular concerns. The combination of firearm ownership and any report of mental distress could potentially justify warrantless entry. Critics worry this creates a backdoor method for conducting searches that would otherwise require judicial approval, especially in states with red flag laws that allow temporary firearm confiscation. The mental health aspect adds another layer of complexity. With approximately 1 in 5 American adults experiencing mental illness annually, millions of citizens could potentially be subject to warrantless home entries based solely on concerned reports from family members, neighbors, or acquaintances. The ruling essentially allows third-party reports of bad feelings to trigger constitutional exceptions. Defense attorneys nationwide will need to adjust their strategies when challenging warrantless entries. Rather than arguing probable cause was lacking, they'll need to demonstrate that no reasonable officer would have believed entry was necessary under those specific circumstances. This shifts the burden significantly, as reasonableness is evaluated from the officer's perspective without the benefit of hindsight. Law enforcement agencies will likely update training protocols to reflect this ruling. Officers will be taught they don't need probable cause for emergency welfare checks, but must articulate specific objective facts supporting their belief that someone was in danger. Many predict an increase in warrantless entries as officers feel more confident courts will uphold their decisions. The unanimous nature of this decision sends a powerful message about the current state of Fourth Amendment jurisprudence. When justices across the ideological spectrum agree that officer safety and emergency aid override traditional warrant requirements, it signals a fundamental shift in how courts balance individual privacy against collective security concerns. This ruling will immediately impact thousands of pending cases across federal and state courts. Any case where evidence was suppressed because courts found officers lacked probable cause for emergency entry must now be reconsidered under the objectively reasonable standard. Prosecutors will move to reinstate evidence in previously dismissed cases, while defendants who won suppression motions may see their victories reversed. The practical reality is that your home's protection under the Fourth Amendment just became more conditional. While the castle doctrine remains, the drawbridge can now be lowered based on an objective assessment of emergency circumstances rather than the higher standard many assumed was required. This evolution in constitutional interpretation reflects changing societal concerns about mental health crises, gun violence, and officer safety. What makes this particularly significant is how it intersects with modern technology and social dynamics. In an era where concerned citizens can easily contact police about social media posts, text messages, or overheard conversations, the threshold for triggering emergency aid exceptions becomes increasingly relevant. The combination of lowered communication barriers and clarified legal standards creates new vulnerabilities for privacy rights. For those concerned about protecting their Fourth Amendment rights, this ruling emphasizes the importance of understanding exactly when and how police can legally enter your home. The objectively reasonable standard might sound reassuring in theory, but its practical application depends entirely on the specific facts and circumstances evaluated after the fact by courts. The long-term implications extend beyond individual cases to fundamental questions about privacy, autonomy, and the proper role of law enforcement in American society. When the highest court unanimously agrees that warrantless home entries are justified based on third-party concerns and officer observations, it reflects evolving attitudes about the balance between individual rights and collective safety. This decision doesn't exist in a vacuum. It's part of a broader trend in Fourth Amendment jurisprudence that generally favors law enforcement flexibility over rigid constitutional protections. Each exception carved out for officer safety or emergency circumstances slightly erodes the general rule requiring warrants, creating an increasingly complex web of situational standards. As this new standard gets implemented nationwide, Americans will need to grapple with its real-world consequences. The same constitutional amendment that once stood as a nearly impenetrable barrier between citizens and government intrusion now contains enough exceptions that warrantless entry has become legally justified in an expanding array of circumstances. The case of Trevor Casier will be remembered not just for what happened to one man in Montana, but for how it reshaped privacy rights for hundreds of millions of Americans. When vague concerns and silent homes can legally justify forced entry, the Fourth Amendment's promise of security in one's own home takes on a different meaning than what previous generations might have understood. That's it for today, folks. See you in the next video.